Hello, welcome to Cutler Legal, Basic Law. Today we're going to talk about contracts. The first thing is, what is a contract? It's traditionally been referred to as a meeting of the minds. It's when two parties or two entities come to an agreement as to a transaction or how they're going to behave amongst themselves. That is the contract. That could be reduced to writing, which we call a memorialization, and the writing is a reflection of that meeting of the minds. Now, a contract can either be in writing or it can be orally. There are only a few contracts that have to be in writing. And there's a law called the Statute of Frauds. Every state has a Statute of Frauds, which oddly named, but means what contracts have to be in writing. Often it's like property, the sale or rental of real property, leasing real property, guaranteeing a loan for somebody else, things like that. Very, very limited matters. Mostly everything else can be oral or in writing. And a oral agreement, you just come in to prove up the oral agreement, as people testify as to what different people had said and agreed to, and looking at how the parties perform. That's an incredibly important element. How did the parties perform under what is being argued to be the contract? That can be evidence of the existence and the terms of the contract. With regards to writing, you don't have to have a single writing. You can have multiple writings. When combined, they make up the contract. You might have, for example, emails, exchange of emails going back and forth. When you take those emails as a whole, they can constitute the totality of the contract. There are certain terms that are required for a contract. You need to know who the parties are, and you need to know what you're giving up and what you're receiving in the contract. And what I mean by giving up or receiving, what goods or services are being provided, what monies are being paid, when the monies are to be paid, when the services and goods are to be provided, when the contract's to begin, and when the contract's to end. And if you don't have an ending point on the contract, many states will allow either party to terminate the contract at any point, because the contract can't go on forever. It has to have an ending date. So if you don't have agreed to ending date, the courts will say that either party at any point in time can go, hey, contract's over, and terminate the contract. That's very difficult when you're in a service situation. Halfway through giving the services, either side terminates the contract. That could be very problematic. Importance in drafting a contract is clarity and completeness. Describe what you are agreeing to. What are the circumstances around it? Because when you write this contract, you're not writing for each other alone. You're writing also for the court. If there's a dispute, a judge has to come in and interpret what the parties agreed to. And in order to do so, the court's going to look at the writing, if it's in writing, and read that. And what people often do is they don't put everything in because they go, oh, we know what we're talking about, we'll just shorthand it, we've got a clear mind. Well, that's useless for a judge because the judge wasn't there. He's not in your mind. He doesn't know what you're thinking. And very much come out with the wrong decision because he doesn't or she doesn't have enough information. Two, the parties themselves forget what they agreed to. Over time, they forget, or they forget out of convenience. Oh, I don't think I agreed to that. I don't remember agreeing to that. Well, we talked about it. Well, it's not in the contract. Or if you're dealing with a big company, the person you negotiated the contract leaves and someone else comes in and they don't know about the agreements and they will say, something else. They'll say that the parties agreed to something entirely different. What is a breach of contract? Breach of contract is when one party fails to abide by a material term. That's not just a little term or a term, it's a material. A core term has to be breached. If a core term is breached, that gives rise to a breach of contract claim. What do you do when you have a breach of contract claim? You have to go to court. Contracts do not enforce themselves. God doesn't come down and enforce a contract. It's like speeding on the highway. People don't follow the speed limit because it's the law. They follow it because there might be a police officer hiding in the bushes up the road. They'll give them a ticket. A ticket will cost them money. It's embarrassing standing on the side of the road as people are zooming by and you're getting written a ticket, and your insurance rates go up. Yeah, you're delayed from your appointment. All those reasons. That's why people don't speed, not because it's the law. Same thing with the contract. People don't necessarily follow the contract because it's written down. They follow it because they're scared of the consequences. So you always have to be prepared to go to court to enforce that contract. That's why you want to be absolutely clear in your obligations. So when you go to court, the court knows what you're seeking to enforce and you have a better chance of enforcing it. What can you get from the court? Damages. If someone has to provide goods and they didn't provide it, you had to go get the goods from somebody else, or you get the extra cost of getting those goods. Or if the services were defectively provided, the cost of the services. Or if the goods or services were not paid for, the cost of the goods or services. Or in some cases an injunction, requiring somebody not to do something as a result of a contractual term. Those are all some of the types of damages. Sometimes consequential damages. I entered into a contract that you were going to build me widgets, and you knew that I was going to put those widgets into a bigger machine that I was going to sell, and I needed those widgets for that machine to sell that machine, and you don't provide me those widgets. Not only is it the cost of getting those widgets, but it's delay in making those machines and selling those machines. There might be some consequential damages above and beyond the contract price that I also would be entitled to. And the other variations of damages that are available. Okay. I hope that was helpful. Thank you.